Hearing in the appeal, Mills against Mills.
Yes, Mr. Clayton. We've, of course, all read the written arguments from both sides in this case, and we thought we should make it absolutely plain at the outset that you are to limit your arguments to the single ground on which you have been given permission to appeal. You are not entitled to resurrect grounds on which you were refused permission to appeal to the Court of Appeal, or grounds on which you were refused permission to appeal to this court. This is not a case about the general principles applicable to periodical payments or their variation after divorce. It is a case about the one ground on which you've been given permission to appeal. Can we make that clear? Because there's a great deal in your written argument which is not relevant to that and which we will not permit you to expand upon.
My lady, you make that very clear.
Well, we have discussed it. My lords agree with me.
I'm sure of that too. Lady, yes. Well, I was going to ask you for an indication or a steer very early on in my argument, but I haven't had to say a word before I've had that steer. I do notice, and obviously your lordships and your ladyship will have noticed as well, that the ground you have given us permission on is in fact ground one of our appeal to the Court of Appeal. And it was one that we wanted to bring to the Court of Appeal's attention, obviously. As you know, we were denied permission to advance any grounds at all to the Court of Appeal. But insofar as you say we can't have permission in respect to the Court of Appeal, that in fact is one ground, the first ground, that we attempted to take to the Court of Appeal. So I only make that point clear because that ground is not in our grounds to this court.
But that's because the Court of Appeal departed from what the trial judge had done, and of course part of your argument will no doubt be that they had no good reason so to do. But they having done that, it raised the issue on which you were given permission to appeal to this court.
Yes, well, my lady, absolutely. But that's why we didn't rely on that ground particularly as the forefront of our appeal to this court. We didn't know what view this court was going to take, obviously, of whether or not our wider point that the specific ground which we'd raised in the Court of Appeal and that you have given permission on today was one which incorporated other elements of the other points that we made. And so, although I understand the steer you've given me very clearly, what I still am not entirely sure about is the extent to which some of the points that we say arise in the case generally can fairly and properly be dealt with under the overall heading of the increase in rent on the basis of the capital payment.
Well, no doubt we will make observations if we feel that you are straying from that, but you were given permission to appeal on the ground that there having been a capital settlement at the time of the divorce, which was intended to cater for housing needs, was it appropriate for the Court of Appeal to increase the periodical payments in order to cater for housing needs, further to which, was this a case in which it was appropriate for the Court of Appeal to interfere with the exercise of discretion by the first instance judge?
Yes.
I mean, it might very well be one of those cases where the first instance judge's decision could not have been appealed successfully, whichever way he had gone. You know, whether he had left the periodical payments as they were or whether he had increased them in the light of the housing situation. It could be one of those cases. I'm not saying that it is, but it could be one of those cases. But that's the ground. So a great deal of what you say in your submission is simply not relevant to that ground.
Perhaps I could just add to that, Mr. Cayford. In your case, in numerous places, you attack the trial judge's decision. You are not able to attack the trial judge's decision today. You have to defend the trial judge's decision.
Lord, I fully understand that too. I just wondered whether, if we're talking about an increase in the rent, this is a case, therefore, about an increase in periodical payments to reflect a found rent shortfall of £341 a month. Forgive me, but what I'm still not entirely sure about is whether the principle of the rent increase, the £341, to get to a figure of found needs. Whether or not the principle behind that would encompass the principle of paying rent at all in circumstances where this husband has made a capital lump sum to the wife in 2002 to provide for her housing.
The trial judge, on my analysis, did order you to pay 60% of the rent, but he did not order you to pay the other 40%. You have to defend a decision that you need only pay 60% of the rent.
Lord, it very much circumscribes the
It does.
the attack that I can make on the Court of Appeal. And I was going to say that it wasn't part of my approach today to attack the trial judge, save insofar as his judgment had been endorsed and promulgated by the Court of Appeal, because he came to certain findings both ways. The Court of Appeal simply adopted, it would seem, most of the findings and most of the figures, and came to their conclusion. And I wasn't sure, and if your Lordships are telling me that the answer is now very clear, that the acceptance by the Court of Appeal of the overall global approach to maintenance, variations of maintenance, is not something that's up for discussion at all, well then obviously it circumscribes most of what I was going to say completely. And so if the debate is only about £341, then so be it. I was going to say, before the helpful steer from your ladyship, that it's not often that a case of involving £341 per month worth of rent would find its way to the Supreme Court.
Well, that was your choice.
Well, my lady, yes, of course it was. But then again, it was permission that was given. And what we didn't know, and none of the academics in the case knew, is whether or not this court, and I think we made this point in our skeleton, in our written case, we weren't quite sure the extent to which that meant that the case interested your Lordships or not.
With respect, Mr. Cayford, you presented us with several grounds of appeal. We gave you permission to appeal on only one of them. If that wasn't clear, I am very, very sorry.
Well,
I hope it's clear now.
No, it's completely clear now. There were different views, but anyway, you've made the position entirely clear.
But it is paragraphs 40 and 41 of the Statement of Facts and Issues. That is a very focused question. The two paragraphs are slightly differently worded, but they're addressing, as I see, the same point.
Lord, yes, certainly, and to that extent, and I accept. And if the aspirations, or if the thought process that went into creating this document, went into creating the notice of appeal, is one which has fallen on fallow ground, then I have to accept that. There's nothing much more I can do. I don't know whether I need 2 hours to, as it were, go through my written case. Because
well, you're not going to go through your written case, are you? You're only going to focus on the bits that are relevant to the issue that we have. And you may or may not need 2 hours, but you'd be doing an amazing job if you took 2 hours to...
Well, I don't want to do that kind of amazing job, my lady. It sounds as though I would be doing a much more amazing job if I confined it all to a matter of minutes, which may be the natural consequence of what your ladyship said. So, what I'd intended to do, and I only say this just to see that this fits in with exactly what you've said, I intended to deal head-on with the scope of the appeal. That now is not something I need to deal with. I'd intended to deal with this in 5 sections. That would have been the first one. I wanted to deal with it because obviously Mr. Fearn, learned friend, had taken this point in his written case, so it doesn't come as a surprise. It's a disappointment, but not a surprise. I'd wanted to make a number of headline observations about these sort of cases, and bearing in mind that there's quite a lot of jurisprudence about this sort of case, ongoing maintenance claims, Section 31 applications, the principle of North and North, the principle that came out of Vincent Wyatt about needs generated, relationship generated needs, and I was going to make a number of concessions and observations about that. I was then going to deal specifically with the facts of this case, which may be something that I would be entitled to deal with untrammeled, because you will have to make a decision on this basis as to whether or not the extra £341 a month is to be payable or not, and that's the limit of it. I was then going, of course, to deal with some of the authorities, which may or may not be relevant now, and I was going to deal with some of the wider issues. And you'll know that we've included in our skeleton a number of academic discussions, a number of academic papers, some observations of the current president, the observations of my Lord Wilson on this topic generally, and it seemed to us that those observations would inform the debate, however narrow it might be. And if it's to be as narrow as this, I would respectfully suggest that it informs this debate. I imagine that your lordships have read those observations and those speeches, those that didn't write the speeches in the first place. I imagine that the issues that arise out of those speeches are very much known to your lordships. I also am aware that my Lady Hale also addressed these issues at the resolution conference just the other day, and indeed addressed the Scottish issue, which was something that I was going to trespass onto.
We were seeking to say that that issue and any potential reform of the law is not before this court, nor are the leading decisions of the House of Lords, in White and White, and Miller and Macfarlane and Macfarlane, they're not before this court. They are the authoritative interpretations of the relevant provisions, and so that's where we are.
Yes.
You do have a point of law of some considerable importance to address, and I suggest you get on with it.
Yes, it's identifying precisely the point of law
Well,
that survives the scalping.
I hope we have done that.
It is difficult for you when you come to court with a wide-ranging set of submissions. But, Mr. Cayford, you're such an adroit advocate, you're going to be able to cope. It seemed to me, and in due course, both you and Mr. Fian will correct me if I'm wrong, that the three most relevant decisions for us today would be Pearce, North, and Yates.
Well, Lord, that gives me some comfort that some of this can be addressed, and I will certainly do so.
If you would like, Mr. Cayford, I appreciate that we have perhaps preemptively restricted the scope of your submissions. That means you will have more than enough time. If you would like us to adjourn for a few minutes so that you can regroup and consider what you're going to concentrate on, I'm sure we will be happy so to do.
Well, Lady, it's probably a good idea. I'm perfectly happy to go ahead now if you want.
Well, as Lord Wilson says, you are an adroit and very experienced advocate.
So he says, and that's very kind of him, and I will be as adroit as I can, but it might just help everybody else if we can get the red pen out and cross out the first 75 paragraphs of what I was going to say.
Well, shall we give you 10 minutes, Mr.
That would be very helpful, thank you.
We'll do that.
Lady, I'm very grateful to you for the time to consider this. It seems to us that effectively we are defending now the judgment of His Honour Judge Everall, and in particular, in paragraph 73, which you will find at MS 160. I suppose paragraph 71 is where it begins, where the judge thinks that periodical payment should be continued. to reflect the fact that the wife has lost all her capital and should now, therefore now has a need to rent, the contribution which the husband makes should do no more than enable her to meet her bare minimum needs, and the periodical payment should be aimed at alleviating significant hardship. That's his finding. The shortfall he's dealt with, it would be reduced if the rent element were excluded. That's self-evident. In my judgment, it's fair the husband's contribution to the wife's needs should not include a full contribution to her housing costs, implying there that it should include some part contribution to her housing costs. She had the opportunity, she spent the capital, her needs have been augmented by the reason of choices she's made since the order in 2002, and her earnings have only been at a modest level. Just pausing there, it would have been one of my submissions, and I hope it still can be one of my submissions, that when one looks at the wife's own figures, and I'll come to this if I'm allowed to trespass into the facts of the case, but if one looks at the wife's own figures, it is abundantly clear that in 2012 and 2013, she had covered, or almost covered, the entirety of her needs, even taking into account rent. And I'll come back to that point if I'm allowed to. So what we're saying effectively is that on her own figures, by 2012, she was effectively self-sufficient at that stage. The figures, and this is a broader point, but it's an important one, we say, a factual point, the figures that the judge took, not attacking it obviously because I can't, but the figures that the judge took in 2015 were those that related to 2014. And to be fair to him, he took those figures in respect of the husband and the wife. But not part of our appeal, but in fact, by 2012, on her own figures, she had achieved sufficient income to cover everything that she said was a reasonable budget when she presented her case or resisted, well, she presented her case and resisted the husband's case in 2015.
So you're saying, if anything, the judge was generous to the wife in the way in which he alighted upon the figure for her earned income?
Very, Lord, yes. Very. And again, forgive me if I trespass, but if the intention, the underlying intention of any application of this kind is to give a payee a gentle steer towards independence, and if on an application under Section 31, one has to look at the facts either de novo if you accept the Flavel test, or on the basis of what was intended by the by the original order under Section 31(7), either way, if that's the general intention, you can look at what had happened by 2012. And by 2012, had this application been before His Honour Judge Everall on his figures, he would necessarily, we say, have concluded that by that stage she had become self-sufficient. And we say that compounds the unfairness in the case, and this is without going at all off into the trespassing area of Fairness and Miller and McFarlane and the other cases that I won't refer to. But at that stage, that snapshot in history, she was self-sufficient. And it's very bad luck, one might think, on a payer, for the payer to choose a bad moment in history to bring his or her, but usually his, application for a downward variation or a termination of those maintenance payments. And it does become something of a lottery, we say, when you choose, particularly if, and one's bound to say in circumstances like the present, one doesn't know what the payee's financial position is. And if, as we would say, with respect and taking everything from the judgment, the payee hasn't given a full account of her own finances or her own earning ability. So that's a factor, we say, that can't be excluded. And I'll come to Pearce and Yates in a few minutes, but that's the background to us dealing with Pearce and Yates, the factual background in this case. I'll say a few more words about the facts until I'm prevented from doing so. But anyway, that's that. So paragraph 73 then of the judgment In my judgment, £1,100 per month represents a fair proportion of the husband's available income. And I've made the concession already that, or the point, I should say, that the judge took the husband's income as at 2014, and he concluded, there's another mathematical error in the narration, which I'm sure your lordships have already picked up, but he concluded that the husband had a net income to him of £48,000 per annum at that stage, with the extra £7,000 to his second wife. And it was on that basis that he was dealing with the party's finances. And so of the £48,000, the judge ordered £1,100, £13,200 to be paid over. That was the fraction. Lord Wilson defined it as being 40% of the rent. I'm not sure from this judgment whether one can say that the judge actually carried out that calculation. It looks rather more as though the judge took a much broader view, looked at the wife's revised schedule of needs, which you know that she put in on day one of the hearing in front of His Honour Judge Everall, and concluded, well, you see what he concluded. He concluded that that's a fair proportion. Such periodical payments goes towards meeting the wife's needs. The wife will have to adjust her expenditure to live within her means. And I'm satisfied that the husband can afford this level of payment and at the same time meet the needs of himself and his new family, and that's obviously his second wife, his child by his second wife, and his other, as it were, second marriage contributions and obligations. So that's the basis that, as it were, we're defending now. Lords, on that basis, and from that point, may we make these observations. May we look, please, at some other aspects of the facts first. I'll come back to Section 31, to Pearce, North, and Yates in a minute. And may I just say that, as it was a prelude to that, this application is governed by Section 31, and it may well be this court's interpretation of Section 31 and Section 37 that will apply to its decision in this case. And I won't trespass, but your lordships will be aware that various different courts have said various different things about the application of Section 31(7). This court and other courts have said that the underlying rationale in any of these cases is the question of fairness. I won't trespass further, but those must be the underlying leitmotif of any application for the variation of maintenance, such as the one we're dealing with at the moment. So, Lord, can I rattle through a few pertinent facts to see where it takes us on the remaining principles? Firstly, the youth of the parties. They were 20 and 21 at marriage. They were 32 and 33 at separation, and they're now both 52. So in this case, this husband is currently looking at about 50 years, or perhaps a little more, of maintenance of his former wife. There was no review provision inserted in the Everall order, or indeed the 2002 order, even on retirement. It was asked for in 2015, but His Honour Judge Everall didn't give it, and of course I'm defending his judgment. He could easily have inserted one, but he didn't. And I say he could easily have inserted one because this was something that the Court of Appeal in Waggett was dealing with fairly recently. And there's a relatively modern case involving Section 31 that I would have submitted might have been relevant to this case. But, Lords, we would suggest with respect that for this husband to be in a situation, he's now 18 years after separation. The party's child, as you will know, has grown up, starts his first job next month, has gone through university, and is no longer any obligation, financial obligation, on either of the parties. Social obligation or social pleasure, certainly, and we would say that applies to both parents. But one does wonder, looking at the net effect of this decision overall, whether it really is fair for a husband to be maintaining a wife without any prospect of review, save for a further application, which is time, money, stress, and so forth, during the 50 years from the moment that the parties separated. And it is, of course, something of a lottery. And this case emphasizes the nature of the lottery, that it all rather depends whether or not, for example, in this case, Mrs. Mills were to remarry. If she does, then it's a bonus for Mr. Mills. Does she have an incentive to remarry? Well, that will depend on the circumstances as well. But it's something wholly outside Mr. Mills's control. Is there a steer to independence in the idea that we're building into this case, 50 years of financial dependence? No, is the answer to that question. Is it surprising that the popular press refer to this as meal ticket for life and a life sentence and that kind of thing? It's not surprising. I'm not advocating that, of course, and I understand that that's an unattractive expression. I completely accept that, but it's not surprising that there are those who are unhappy about that, and indeed, that's a point made by my Lord Wilson in his address to the Bristol students last year. It is not surprising, he said, that a number of husbands in that position are very unhappy, and he observed, quite rightly, that in many cases it's their second wives, or subsequent wives, who are even more unhappy than they are. And the stress and toll on second marriages is something which shouldn't be underestimated in the overall assessment of the net effect of what these orders are producing. My Lord, the second factual issue is the question of qualification, and it goes to the wife's earning capacity. Well, the wife has had an earning capacity found by His Honour Judge Everall as of 2014, and we know what that is. He said it was about £18,500 net. But these parties were both qualified before the marriage. They were both working before the marriage. They both had independent incomes before the marriage. And indeed, it's the wife's case that she was earning more than the husband at that time. Her qualifications, I beg your pardon, which are set out in the Statement of Facts and Issues, are threefold. Am I still speaking too quietly? Her qualifications set out in the Statement of Facts and Issues are clearly sufficient to enable her to have generated that self-sufficient income before the marriage and during the marriage. And there's no issue about incomes until the parties had their first child in 1994. And we accept that. And that's something which His Honour Judge Everall had to deal with and grappled with when he was deciding whether or not events that have occurred since 1996, which was the miscarriage which both parties deeply regretted, but whether events since that time and the medical issues that have arisen since that time were relevant to the case he had to decide. And you will be well aware from reading his judgment that he, having considered all the medical evidence that was put before him and having considered the inquiry agent's report, he made a finding that this lady was not trammelled by her physical difficulties with effect from about 2010. So on the question of qualification and earning capacity, are these parties in a position to make their own way in the world, particularly now that their dependent child is no longer a dependent? And the answer to that must be yes, they are both able to make their own way in the world. The decision that I'm defending included the proposition included in his judgment by His Honour Judge Everall that having met the wife and having spoken to her and having heard her cross-examined, he wasn't sure that she was going to attract the clients to get the fourth day of, well, the third and the 2.5, the third half day and the fourth day. He wasn't satisfied that she would attract sufficient clients to fill that gap. But of course, if she did, it must be a matter of common ground between us that her figures would then look perfectly satisfactory, and if she was able to make the sort of income that you've seen in 2012, 2013, and 2014, and there's a schedule to which I'll refer in just a moment, just simply setting it out, not giving you any new information, but simply tabulating the evidence we've got. If she's able to make that sort of income working 2.5 days a week, then if she is able to work in that same profession for 4 days a week, then her needs will be completely satisfied. The third point, Lord, of course, is the child, but I've made that point, so I'll move to the fourth. The basis of the order, as a matter of fact, it's our case that Mr. Mills was completely sympathetic to the medical difficulties that Mrs. Mills had back at the end of the 90s and post-separation. Separation was very early in 2000. So they hadn't been living together or communicating very much for the 2.5 years between separation and the time that the matter came to the FDR before District Judge Black in June 2002. And without trespassing unfairly into the without prejudice correspondence, what we do know is that the parties came to a consent order, a consent agreement, in front of DJ Black on the day. We also know that there was correspondence prior to the FDR, because some of that is in the bundle, and I was going to refer your lordships to it in just a minute. Not that without prejudice, that's been taken out because we can't agree that it should go in. But there's some open correspondence prior to that. So my point is this, that this lady, represented at the time, as it happens, by Richard Todd of Council, entered an agreement at that time that would provide for her on the basis that she couldn't work. And I don't know if I need to refer your lordships to the Form E, or whether the provisions of the Form E are very firmly in mind. It's MS 882 if I do, where she said that she couldn't work at all. And there was no time limit put on that provision.
So that's the 2002 Form E.
2002 Form E.
Right.
Would it help your lordships to look at it, or is it not necessary?
Perhaps we might do that briefly.
Well, if your lordships would. It's Appendix 4 at 311, or as I say, MS 822. If I said 822, I meant 882, I'm sorry.
That sounds more like it.
Yes.
Earlier you said 882.
Yes. Well, it was probably me then that made the mistake in the statement of facts and issues. There's obviously an element of arithmetical dyslexia creeping into my presentations now, but in any event, MS 882, I am recovering from several minor and major gynecology operations. I am still under medication and as yet unable to be employed. Now that short paragraph informed the entirety of the 2002 proceedings, as is very obvious from the subsequent correspondence, which I hope your lordships have read, but if not, I'll address you and take you to. So, in fact, Lords, it's probably a good moment to do that now. Can I do that? Because what we know at that stage is that there was this consent order, and I assume I don't need to take you to the consent order itself. It was a consent order that effectively gave the wife, we say, 94% of the liquid capital. We say that there was no other liquid capital apart from the bit that the husband got, the 6%. We say that the pension at the time was worth £14,000. And we say at the time, he says, in his Form E, in his presentation in 2002, that his businesses were worth a total maximum, capitalized in some way, of £49,000, but of course completely illiquid. And we have used in our schedules, again, not to take your lordship's time up going to the various schedules, but we've used Mr. Todd's figure at the FDR of £117,000 for the husband's business, because that's the figure that he put into his schedule.
Was the wife a shareholder in those businesses?
She was.
Yeah.
No, she was. And if there's an issue about the extent of her involvement, then we could go into that, but I assume that's not the case, and I gather from your ladyship's demeanour that I don't want to at all. I don't want to, but our point is that she was a shareholder in a business that was completely illiquid, that a business that had to succeed or had to be an income generator for the maintenance to be paid and for both parties to be supported. So, but one can't say that this was a business that was worth the sort of value of the house or that it was liquid. And that's why we say there's this very strong element of double recovery, even at the beginning. And even in 2002, would a district judge in the county court, as it then was, have given a lady 94% of the liquid capital to rehouse and a full open-ended maintenance order without any question of review or reconsideration if there hadn't been the health factor which determined the entirety of the outcome? And we say even in 2002, when joint lives maintenance orders were clearly much more prevalent than they are today, a court wouldn't have done that. It was entirely for that reason. And so that's why, if there's any doubt about this, would your lordships turn to MS 986 and MS 312, please? It's Appendix 3, page 245. We can start with this. This is a document that His Honour Judge Everall referred to on a couple of occasions and clearly had in mind. This is a letter sent by Mr. Mills's solicitor to that of Mrs. Mills.
Sorry, what was your MS number?
813. Oh.
You said 986 at one stage, but we can't.
You then said 916.
My lord, I did.
813. 813. Yes.
813, yes. Lord, I'm so sorry.
That's a letter of the 5th of November 2002.
It is. I do apologise. There's been a bit of confusion on the MS numbering of the bundles, for which we apologise if apologies are necessary.
Yes, they are.
They are. Well, in that case...
Sorry about that.
No, not at all, not at all. It's caused some concern to those instructing me, and they have tried very, very hard and worked very long hours, if I might say so, to try and correct the difficulties that appeared in the numbering pagination of these bundles. And so if it has caused confusion, we apologise. If you're with me at MS 813, letter of the 5th of November, this is a letter that was written some months after the FDR, and it was a letter that was written just at the point of selling the matrimonial home. And you'll remember the figures, I trust. But what the husband's solicitor is saying is that this is the price. We've been surprised, therefore, to learn that Mrs. Mills is purchasing an alternative property for $345,000. The information on which the court made its order in June was that your client had no intention to remarry or cohabit with anyone, and she had no other income save maintenance for our client as per the proposed order of £1,100 per month and £300 for the party's son. And His Honour Judge Everall makes a finding in his judgment that that's what the expectation was at the time. She then goes on to say, this is my client's solicitor, then solicitor, she's clearly going to need a further £100,000 or so to proceed with this purchase. It doesn't seem to us consistent with the information provided to us in the court regarding her income, her future intentions. It's therefore reasonable to ask whether the property is being purchased alone by your client or whether she's anticipating any contribution in capital or towards the mortgage from a third party, and how she's proposing to fund a mortgage of that size. If it transpires that your client has simply obtained a non-status mortgage, and it's her case that she'll fund it from the maintenance payments, then we think we ought to make clear at this stage that the purchase price which she's proposing to pay is substantially beyond that which was contemplated at the time of the proposed order. And on any future application to vary the maintenance by either party, this is an important factor to which we'd ask the court to have regard. In other words, our client will not consider himself liable in any way for the mortgage payments and will reserve the right to draw this letter to the attention of the court. Which he did in 2015, and which I do today, because it goes very much to the North, Yates and Pearce points. And she was very much on notice at the time. It also indicates, does it not, that if you combine what she said in her Form E and what the solicitors on the behalf of the husband are saying in November that it was the husband's belief and expectation, and not surprising based on what she said in her Form E, that there was no income and no other source of funding. And he might even say that he was rather conned into agreeing an order of that kind, because as we submit today, he wouldn't have done that had he had any indication that in fact her earning capacity was as nil, as negligible as she was saying.
Mr. Cayford, you'll correct me if I'm wrong. I think in her Form E in 2002, she had said that she aspired to buy a property for about 345, 350,000. I
Lord,
think in your client's Form E, he said that she could acquire a property for a good deal less.
Yes.
We know that the property she bought for 345,000 was in Weybridge.
Yes.
I mean, we all know that that's a very expensive area, but I think I'm right in saying the son of the family was then in school there.
Lord, yes, he was in school there for a short time, and the party's centre of gravity was between Weybridge and Guildford, and in that general part of the country. And I'm sure you don't want to go into a debate about areas and house prices and so forth, but it's absolutely true to say that the husband produced some documents, in fact, they're at the beginning of the bundle you've got in your hand, that showed that you could get properties in the Guildford area, which is where he thought she wanted to live.
Yes.
Because that's where they lived at the time. And one of these properties, and I'm not sure which, but one of them is on the very estate at which they currently lived. And that's why he produced Guildford properties.
Yes.
His view, and evidenced by those documents, was that you could buy a suitable property. It's not a mansion, nothing very fantastic, but it's something that won't have a mortgage, was his point. And you can probably gather from the papers that you've had before you that he is the cautious one, and she isn't. And so his case was that this is reasonable, this is fine, this is sensible. And he settled the case on what he thought the position was. And as I say, it's not just what he would say. This is what his solicitor has said in what's a really quite instructive letter written at the point of sale of the former matrimonial home. And it's clear from that, unless the solicitor is acting on false instruction, that he was genuinely surprised at what had transpired. And he never accepted for a second that the mortgage element, which wasn't included in the £1,100, the aspiration to buy a property for 345 with a mortgage was, because at that stage, and per the party's expectation of the house value, the net sale proceeds of the house were going to be more like £210,000, something like that, on the basis that £400,000 was the estimated sale price. Which is why they agreed that the first £400,000, or the net result of £400,000, would go to the wife, and the balance would be split evenly, and not an uncommon scenario. And in fact, they were lucky to the extent that it sold for £445,000, which meant that he had a small amount of money himself.
I mean, I'm sure it doesn't matter. There is a discrepancy between paragraph 14 of the Statement of Facts and Issues. The husband received 22,500, and the judge's finding, the husband received 40,000. It
Yes.
couldn't matter less now, but for the point of view of reciting the history,
Yes.
which is it?
Lord, we think it's the Statement of Facts and Issues. We think it's the £22,000.
I see.
We have obviously asked that question.
You think the judge made a mistake?
We do.
Very well.
We do.
Very well, yeah.
But I...
Now, you've pointed out that the wife was saying in her Form E that she had no earning capacity at that time.
Yes.
On the evidence before the judge in 2015,
Yes.
what was the time when she started to earn again, Mr. Cayford?
Well, my lord, it's a very good question. Can I answer it in this way? May I ask you to turn to, I hope, MS 312. Is it 312? It may not be. Appendix 5, page 524. Could you tell me what that reference is? 524.
What's the other number?
It's the Appendix 5, page 524, internal. I can tell you, actually. It's MS 1098.
Thank you.
Well, I just want to make good the correspondence, because you've got, opposite the letter of the 5th of November, the reply from the solicitors. That's at MS 814, which I haven't referred you to, but they dispute. And the reply, effectively the reply, is this. It was not made clear at the FGR it was your client's intention to purchase alternative accommodation at the price she has done. We think it's reasonable to make sure that that fact is placed on record. We also think it's reasonable to point out that for however much both parties may wish it otherwise, the relationship between them cannot be finished for as long as our client is liable to contribute to periodical payments. And that's why we consider it important to make the position quite clear now that our client will not accept the additional mortgage payments as representing a valid reason for either an increase in those periodical payments or for any delay in their reduction or extinguishment in due course. And again, unless that's false information, the position could not be more clearly set out, that the husband has been confused and slightly, he would say, possibly deceived, but we don't need to go that far. And this turns out to be what happens. He doesn't know. There's no disclosure that we're aware of further than this as to how the wife was proposing to pay her mortgage of £125,000 on the basis of a maintenance figure for herself of £1,100 per month. But would your lordships kindly turn to Appendix 415, and I hope that's MS 986. And the point about this
Looks like a witness statement by the wife.
it's in fact an appendix to a Form E. It's the appendix to the Form E, and it's a document that we take very great exception to, but I'm not going to trouble the court with it at the moment. And the point that we would make about it is that it's a litany of complaints about all sorts of things, which have never been tested either by the 2002 court, obviously, or the 2015 court either. But the point I'd like to make, Lords, is that about 10 or 12 lines down, she's describing the property purchase. Graham supplied me with property details, 2-bed houses at this price. They were tiny houses, dark and depressing, and you've seen the particulars. Graham said to the court at the time of the divorce he was living in a rented room and could not afford to buy a house for himself. That was true at the time, perhaps, it doesn't matter. I continued working part-time as a beauty therapist to bring in a little money, as I could not live on the maintenance alone that I was receiving. And, my lords, we do draw attention to that because it's not quite what she was saying in 2002. And it may be that that had something to do with how she was able to afford a mortgage of £125,000. Of course, it's all rather non-specific. Working part-time to bring in a little money, what that means is anybody's guess. But it's not what she said before. And if that had been the proposition put forward in 2002, you can surely rest assured that those instructing or instructed by the husband would have asked for details of what she was in fact earning. But they didn't, because she didn't.
But in paragraph 23 of the Statement of Facts and Issues, it's a matter of agreement that the wife resumed work as a self-employed beautician by 2003.
Yes.
So I'm not sure it's going to assist us to speculate whether or not she started work marginally earlier.
Lord, no, certainly, but that's not our point. Our point is that at the time the order was made, she said she didn't have any employment at all.
No.
And she certainly did. And what we don't know is exactly when she started. We thought that she started to work after the 2002 order. We accept as part of the agreed...
Look, I'm sorry, Mr. Cave.
Not at all.
I mean, I don't want to make your life any more difficult, but we have an agreed statement of facts and issues here.
Yes.
That statement says the wife resumed work as a self-employed beautician by 2003.
Yes. Well, my Lord, my Lady, we agree with that. She did. But that's having said she had no income capacity at all in 2002.
Well, she said in her Form E that she was still under medication and unable as yet to be employed.
Yes.
That's what she said.
Lady, yes. We don't
It's not
complain.
open to us to resolve any dispute that there might be about how you reconcile those two statements. They may be completely reconcilable. They may not. But it's not open to us to do that. That's not what this court is for.
No, Lord, Lady, no. But it goes to the factual matrix.
I think it
upon
goes
which-
to how your client feels about things, which is completely understandable.
Well, I would argue that it goes further than that, but if you disagree, then I won't take it any further.
Well, it certainly goes to how your client feels about things, and I say that's totally understandable. But we have the particular issue in front of us to resolve. You've demonstrated what was thought about housing needs at the time the consent order was made. You've demonstrated what your client's attitude was to the actual choice that the wife made, and that is a very helpful point, if I may say so.
Well, of course, Lady, I absolutely do not want, and I hope I've made it perfectly clear, I don't want to take up any time that this court resents that's not going to help this court. But
We don't do resenting here.
No. But in terms of what's wasting your ladyship's time, we don't want to do that either. And if you think it's not relevant to understand our to listen to our case as the basis of the order in 2002, then of course I'll stop there.
No, the basis of the order in 2002 is of course relevant.
Are there some findings of the judge which may help about the basis of the order, Mr. Cave?
Yes,
66 and 67.
yes, Lord, absolutely.
She had an opportunity to house herself without mortgage in 2002. That's a finding of fact.
Yes.
I take it you don't want us to go behind it, even if we could.
Well, no, I can't and I don't.
Quite. 67, it was reasonable for her to be ambitious and to seek to re-establish her business as a therapist, and reasonable to take on a mortgage. So's that, isn't it?
Well, my Lord, that isn't so easy, because
Well, forgive me. All right, you have to explain how any of this goes to whether the Court of Appeal was right or wrong to change the judge's order, which it did on the basis that he hadn't explained why it was unfair. That's what the Court of Appeal said, isn't it?
Lord, the objection, or the only point that we would take about the paragraph 67 to which you refer, is whether or not it can now be said that there's a finding here that it was reasonable for this wife to behave in the way that she did in respect of her properties and her mortgages.
Mr. Caper, there clearly isn't.
No.
There clearly isn't a finding anything like that.
Well, quite.
There is, however, a finding. In fact, it helps you, I would have thought. There's a finding that she started with a reasonable decision to take a mortgage, and that after that she mismanaged her finances. Do you need any more than that?
Lord, no, I don't. But may I just make this point, that on 4 separate occasions in My Learned Friend's skeleton, he argues that there's been a finding of reasonableness in respect of the wife and her conduct of house property purchases and taking of mortgages.
Yeah, well, you certainly need to address that.
Paragraph 69.
Yes.
The wife did not manage her finances wisely. That it can be equated with, it may not be profligacy or prodigality, but it can be equated with mismanagement.
Yes. Well, my Lord, precisely, and thank you, because that's what I was going to say. And I'm only really, in that last sentence, only really dealing with the suggestions made by my learned friend, which, as I say, he does on 4 separate occasions. I've got the references
Okay.
if it becomes of any relevance. But what he also goes on to say, as you will notice in paragraph 67, she couldn't satisfactorily explain in the hearing before me why this had been done or on what the money was spent. This is the further extension. Perfectly reasonable, and we're not going behind that today in the circumstances. We've described how it happened, but she had a mortgage of £125,000. What we see, and we've looked at the schedule of the properties in our skeleton, what we see is that she managed to extend that mortgage from £125,000 to £442,000 in the space of just 5 years. And we say that is extraordinary, and the judge, all the way through, is grappling with this question of how these mortgages were obtained, what the money was spent on, and where it left the wife. And she certainly, absolutely, is the conclusion, she didn't manage her finances wisely. And I would go on to say, and I hope I can say this very briefly, that constitutes mismanagement. That constitutes, we would say, irresponsibility. That constitutes, we would say, recklessness.
I mean, I don't think the epithets matter too much, but you've a very clear finding of fact at the beginning of 69 that there is unwise management of finances, and it's questionable whether you need more.
Well, my Lord, I'm grateful, and I'll very happily move on. The reason that I might have dwelt on it is because the Court of Appeal,
Yes.
in their judgment, made very clear that they were relying on this finding and on the finding that the wife hadn't been profligate or wanton. And we've said, certainly so far as North is concerned, which I'll come to just a moment, that that's not the test anyway.
No.
Well, that's the interesting question, isn't it?
Yes, quite. And that's the finding that the Court of Appeal, or that the way the Court of Appeal dealt with this case, in fact, when it was before them. Whereas if you say to me, here's the finding, is that all you want? Is that all you need? I would say that is all I need. Unfortunately, it wasn't the view that the Court of Appeal took.
Yes, paragraph 13 of the Court of Appeal judgment. He
Yes.
did not find financial mismanagement.
Yes,
Instead, he found that the wife had not been, quote, profligate or wanton.
yes. Lords, you will know, it's our case that that's the wrong test. That's not what North says. And we've devoted some time in our skeleton, which I'm sure you've read, and I won't bore you with any further, but that there's a certain amount of semantics between the suggestion that not managing her finances wisely to the point of having a lump sum of £230,000, reducing it to nothing in 7 years, 5 years, I'm sorry, 7
It's
years.
actually reduced to quite a lot less than nothing,
Well, it
isn't
did.
it? In a rising property market in Surrey.
Lord, yes.
Right.
And you will have presumably read our schedule in our written case as to what the effect was. The first property didn't rise much in value, but the second two did.
Mr. Cayford, now we've reached the Court of Appeal judgment.
Yes.
I wonder whether it might be convenient for you to address us on what might be a puzzling part of the judgment. Let's start with paragraph 14 of the judgment. I've got that on page 125, but I haven't got the memory stick numbers.
Lord, it'll be the same in the core bundle.
Right. Fourth line down.
Yes.
The judge did not give any reason why any part of the trimmed budget, that is why the wife's basic needs budget, should be cut in explanation of why that shortfall should not be met. And before you comment on that, would you go back to paragraph 10 where your submissions are summarised? Mr. Cayford submits that, and then can we go down to C? Although this court cannot know how the judge trimmed the wife's budget, it is clear it was trimmed. Well, bearing in mind we've already read the judge saying expressly, I am going to trim this budget down from needs because I'm not going to visit the husband with payment of all the rent. How did it come about, if you did submit that the court could not know how the judge trimmed the budget? And can you give any explanation for why the Sir Ernest concluded that the judge had given no reason why any part of the trimmed budget should be cut?
Lord, I can't give any reason as to why Sir Ernest came to that conclusion or some of the others. But what he would have done is looked at the paragraph where the judge had decided that that was her claimed budget, and that although he went through the budget and could see that there was this shortfall of £341 per month, she was going to have, paragraph 73 of the judgment, she was going to have to manage somehow. And that's memory stick 160, and we've looked at it already.
But if you'd submitted that the Court of Appeal could not know why the budget was trimmed, then I suppose Sir Ernest was entitled to conclude that the court did not know why the budget was trimmed. But I find all this rather odd.
I think it says how, not why.
How, not why. It's different.
I think we know why the judge of first
Yes.
instance trimmed the budget,
Yes.
and that is simply because he took the view that the capital made available to her in 2002 was a relevant consideration as to whether, having regard to the mismanagement that then happened, the husband should pay the whole of the housing needs thereafter.
Yes, well, he does rather make that clear, doesn't he? That he's saying effectively it's your fault, and bearing in mind that it is your fault, I'm not going to go the extra mile for you. You're going to have to simply manage on what is currently there, even if you might say, and I'd almost be obliged to concede it, there's a slight lack of detailed reasoning. That's the point that the Court of Appeal jumped on. I'm not in a position, obviously, to go much beyond 73, paragraph 73 of the judgment, because that's what he said, and that's what he concluded. And he concludes at the end of his judgment that in all the circumstances he thinks that's fair. I just make 2 points. Firstly, he did the same thing for the husband. He gave a reasonably long judgment. It was a case that went on for 2 days. This was a first instance Section 31 application, of which there are thousands and thousands being made all the time. In other words, he was dealing with this as a first instance judge, and so possibly every single point that's chewed over in these courts, the appeal courts, wasn't necessarily chewed over in that court. Maybe there's a slight element of broad brush. There were a huge pile of documents as it was. We've got the original 2015 bundle in court, and it's a substantial, thick bundle of documents that deal with all sorts of things. He had all of that to deal with, and he came to that conclusion. Might offer another potential explanation. If you were to turn to memory stick 296.
What's the other number?
It's 212.
Is this the 2002 budget?
It is, my lord. It is. And on the page before, you see the Form E budget. And I think we've made the point in our submissions that the claimed budget in the 2015 proceedings was £96,000. That's the asking price that the wife started off with in her Form E, the 2014-2015 proceedings. And to short-circuit the history of that, on day one of the hearing, and we've had this verified by all those who were present at the 2015 hearing, on day one, the wife's counsel turned up with this document, 296 MS, and that became his case and her case.
So this is the 2015?
15.
Yes. This is what the judge had before him. The judge had two budgets. He had the Form E budget, which was very significant, which is a very, very high budget indeed. And I don't want to speculate, but I dare say counsel for the wife thought that he couldn't maintain or support that budget. And on the day of the hearing, he arrived with this budget. And I think you can see that the name of his then instructing solicitor is at the top of it. And it was broken down into the total claim, total sum sought, £4,466 per month. And then the Lawrence, the sons element was removed from that figure to give, as you can see on MS 298, 2982, and that's the figure that the parties worked with throughout the hearing. And that's the figure that has been the wife's case in these proceedings to date. And I don't know, but it may be that this judge, having seen the Form E and having seen that the wife was claiming £96,000 for herself and for the party's child, to be fair, so it's not just for herself, I think it was £62,000 for herself that she was claiming. When she came to Judgment Day, she produced something a little bit more realistic, and this was it. And the judge might have looked at this to see rent at £1,500. He might have gone down the list of the expenditure and wondered whether there was any scope to cut here. He certainly described it as a relatively modest budget, as indeed one might say in some circumstances it is, although there are many surviving on much less than this. He might have seen the expenditure on pets, and he might have thought that was a conscious lifestyle decision, not one for him to criticize, but a decision nevertheless. He might have gone over the page to 297 and looked at some of the personal expenditure, clothes, shoes and handbags, presents and so forth, all things that are nice to have and to spend, of course. But if you're in a difficult financial situation, those would perhaps be the ones that might get cut first. He might then, Lords, have looked at the credit card entry of £435 a month. And he might have been influenced by the submissions that we know were made, that reflected excess expenditure in the past and were not valid, that there were needs. There were certainly, I dare say, debts, assuming they were all correct, and I'm not in a position to go back into all of that now, but assuming they were correct, figures are correct, those reflected previous over-expenditure. Further examples of this lady spending beyond her means. And he might, I don't know, have looked at the next page and seen that MM needs to update her 2004 car, as she's now commuting. And she wanted £200 a month for a new car. We know that she left the marriage with the family BMW and its private plate. We don't know, and we haven't asked what happened to that. But it may be that this judge thought, well, in a situation like this, those sort of items aren't actually what I would call needs. I don't know. It is
I didn't really understand this submission, Mr. Cayford, because I thought the judge had accepted the first figure of 2,982 and had then knocked off the wife's earnings as he computed them to be and got to a lower figure for needs, and then, as he said, decided that your client should not pay for all the rent.
Well, my lord, yes, but if Mrs. Mills had a legitimate rent bill that the husband shouldn't pay for, it might just as well be said, or it might be said against us, that Mrs. Mills will pay her rent, and that would leave other items of personal expenditure that weren't rent, but there were reasonable outgoings for which she should have some assistance.
Well, he might have done it that way, but he didn't.
Well, he didn't break it down in that way.
No, so it's speculation as to how Mrs. Mills could trim a budget. What he did do, and what presumably you say he was entitled to do, was to look at the fact of the earlier capital payment, to look at the fact of financial mismanagement and say, well, while these may be her needs, the husband, it's not fair for the husband to contribute the full differential between her needs and her income.
Lord, I certainly would say that. Yes. And it may be that in itself is sufficient to, as it were, dispose of our attempt to get to the reasons that the judge gave for making the order that he did. He certainly expressed himself in that way.
Yes.
Further questions, and perhaps legitimate questions, have been asked in the Court of Appeal and elsewhere as to how he got to that figure. That figure can be sustained, but that's what he did, and he did it by saying what he said. So there's certainly, you can get from the language of the judgment some element of censorship or censure of this lady's financial expenditure, which the judge may have felt will leave her in a position that she doesn't want to be. She's on her own figures, and they're her own figures, mind. She's short, but I'm sorry, you'll have to sell the cat. You'll have to not have the car, do something like that.
If that is the correct construction of his reasoning, what do you say about the Court of Appeal's reversal of his decision?
Lord, we say that the Court of Appeal didn't pay any heed to his reasoning, if that was his reasoning. The Court of Appeal, afraid to say on both occasions the case came to the Court of Appeal, took the figures as being read, as being gospel, as being established needs that should be met by a payer. And the Court of Appeal did a mathematical exercise that got them from the figure that the judge thought this lady was earning in 2014, and took a figure of £1,500 less the £650, a notional deduction, which, again, doesn't actually get the rent paid, but perhaps that element of the rent would be paid by a lodger or something, or perhaps by the son when he's working. But in any event, the Court of Appeal got to the figure of 2982, or took that figure, deducted the income, and then said the rest are reasonable needs, and therefore that's what the order must be. That's how it happened. It's a very, very simple mathematical calculation based on the premise that her needs had been found and established at that figure, and based on the proposition that she's not to be deducted, she's not to suffer any deduction as a result of her previous mismanagement, recklessness, profligacy, call it what you will. That's what they did. What they did was something, if I might respectfully say so, was a pretty basic calculation. And it didn't, well, I don't want to criticize the Court of Appeal if I'm not appealing that part of it, but they didn't enter into the north part of the debate, or even Yates, or even Pearce. They simply said, here are the figures, this is what's lacking, and this is therefore what the figure should have been. And it was a very rather basic mechanical figure calculation, which has yielded the result that we've got, which obviously we say is not right. And if I am defending His Honour Judge Everall, as I am, he carried out a first instance judge assessment of all the parties. He looked at their demeanour, he made his findings about the wife's health difficulties, and all the other points that she put to him. And he looked at the husband, and he made his assessment of those parties, and he came to his conclusions. Would it be helpful to look very briefly at his assessment of the parties? My Lords, it's MS 149.
We've read all that.
Oh, we've read all that.
We've read all
so
that.
You've now got half an hour left, and the matter of principle is what we're interested in.
Fine.
And the three cases that my Lord mentioned to you
Yes, very well.
at the outset.
Very well. Well, let me
If there's anything else you want to emphasise at the end of your submissions, by all means do.
No, well, I'll move swiftly to the three cases. My Lords, we deal with the North Point at some length, I fear, in our notice, in our written case. And Lord, it starts somewhere around about MS 67.
Paragraph 48.
Paragraph 48. Obliged. I'm assuming that this court knows the facts of North sufficiently well that I don't need to recite them.
Well, I'm not sure you can make that assumption about every member of the court.
Well, let me in that case deal with them
Well, they're
very...
set out in your case.
Yes.
Yep, they are.
Yes, Lord, my Lords, I hope they are. I hope that the relevant facts and relevant submissions that we make arising out of the facts are all set out in this case. It's not the shortest case you've probably ever read, but it's one that we hoped was encompassing in the event that any member of this court didn't wasn't intimate with the case of North and the other authorities that we refer to. But what it does is sets out the fact of the order that was made on an ancillary relief, as it then was, application. She was given a mortgage-free home. She didn't work. She went to Australia. She sold her property and some other assets she had. She got £328,000 from it, invested in the stock exchange. She went to Australia. She didn't buy a house in Australia either, but she chose to rent. Her finances ended up rather disastrously, and she had dwindled her capital to £156,000 by the time of the hearing, which was probably less than 10% of what she'd started with. So very similar to this case, except that in this case, this wife has managed to lose the lot. The wife applied in this court, to this jurisdiction, for an upward variation of the nominal periodical payments that had been put in place just in case. The husband's financial position had improved substantially in the meantime, and so affordability wasn't really an issue for him, it was more principle. The district judge found that the wife's situation was entirely of her own making, but nevertheless required the husband to pay £16,500 to the wife, capitalised at £202,000. And then the case went to the Court of Appeal, where it has been much discussed and much referred to. And indeed, it was referred to in this case, in this court, in Vincent Wyatt. And there's been very much relied on authority since it was decided. And, Lord, the relevant passage is the one I've underlined. It doesn't follow that the respondent is inevitably responsible financially for any established needs. He is not an insurer against all hazards, nor when fairness is the measure, is he necessarily liable for needs created by the applicant's financial mismanagement, extravagance, or irresponsibility. And you will notice, as I pause, that there's no reference to wanton or profligate in that sentence. The prodigal former wife cannot hope to turn to a former husband in pursuit of a legal remedy, whatever may be her hope that he might, out of charity, come to her rescue.
I think you might have added paragraph 33 of Lord Justice Thorpe's judgment, which we've got, of course, in tab 10 of the authorities.
Yes. Let me just find that.
I've got a 155 number. I don't know what the other number is.
477.
33.
Oh, actually, it may not be.
33.
May the 477.
Where is the North one?
It's 477. Yep.
MS 477. Yeah.
Well, we've probably all read that now.
I'm obliged. Yes. Paragraph 33.
Yes.
Yeah.
Yeah. So he's describing her conduct, effectively, failure to utilise her earning potential, subsequent abandonment of the secure financial future provided for her by the husband, choice of a more hazardous future in Australia, together with lifestyle choices in Australia, were all productive of needs which she had generated, and for which the husband should not, as a matter of fairness, be held responsible in law. Even the applicant's subjective sense of fairness should surely not encourage her to expect that someone from whom she was divorced so many years ago should be required in law to compensate her for the financial consequences of ill-advised choices. And again, ill-advised is a useful bridge to the expression used by His Honour Judge Everall. One doesn't even need to go into mismanagement or reckless or financially irresponsible. Ill-advised, virtually the express description given to Mrs. Mills's conduct in this case. And that was what Lord Justice Thorpe said. Of course, in that case, a very small order was made, as it happened. But that was as it were, a consequence of analysing the situation and deciding what was fair, and concluding that Mrs. North wasn't entitled to nothing. She was entitled to a very small amount. But the principle, the headline principle, is is the one that we've read out.
Yes.
Lord, I made reference to this court's decision in Wyatt and Vince in our skeleton by saying that Lord Wilson cited and endorsed the words of Thorpe LJ above, and then in addition dealt with the relationship between needs and the parties' relationship, and said this: in order to sustain a case of need, at any rate if made many years after separation, which we would say was the case here, a wife must show not only that the need exists, but that it's been generated by her relationship with her husband. And he then cites Miller Macfarlane, and indeed a passage from Lady Hale, which your ladyship will know is very frequently referred to, very frequently discussed.
Well, I didn't know that, but...
Well, I can tell your ladyship something then, that I hope is helpful.
It's in fact not so much that the need is generated, because needs, as Mr. Fearn points out in his case, need exists irrespective of what gives rise to the need. At least certain basic needs exist. But of course the inability to meet them through one's own efforts is what is, on the whole, the thing that is generated by the relationship.
Yes.
Difficulty in meeting them by one's own efforts.
Yes.
What some people might call the dependency, but I'm
Yes, certainly.
trying to avoid that word.
Yes. I mean, it's an interesting and difficult area, and it's one that I see that we won't be going into today. But in our written case, I'm reading from paragraphs 49 and 50, and I then move on to paragraph 51. And I'll be stopped the moment I've gone too far, but we've referred to SS and NS, which is another decision of the High Court, Mr. Justice Mostyn, where he addresses a number of these issues, and he goes on to say that...
Well, that's another way of putting what I've just said.
Well, very well.
Seems to be.
Very well. Well, we're happy to accept that.
Don't stop.
Well, it's another way of putting it, lady, and this is slightly the point. These cases have now run from North and Miller, gone through the imprimatur of this court in Wyatt and Vince, a thoughtful and interesting judgment from Mr. Justice Mostyn in SS and NS, which again is one that's frequently cited in the lower courts. A decision of Mr. Justice Charles, where he reviews the authorities and takes what he says is his guidance. What he takes from this guidance is the approach to the statutory task. And he then goes on to talk about these other issues. Aim is independence, self-sufficiency.
You rightly said that this area about the need for the need to be generated by the relationship is a difficult one.
Yes.
Mr. Cayford. And one can think of cases where the wife during the marriage has become ill, or after the periodical payments order,
yes,
when she was working, has become ill,
yes,
and not able to earn anymore.
Yes.
You can't say that her illness is relationship generated by and large. Miss Justice Mostyn seems to suggest that in that residue of cases where the need is not relationship generated, there's got to be something approaching significant hardship. Is that the way you read the judgment? Is that the way the practitioners read it?
It's the way I read Mr. Justice Mostyn's judgment, yes.
Yes.
Certainly. And he doesn't talk about undue hardship, he talks about significant hardship.
Well, it's a big area, this, isn't it?
It is. It's a very big area. It's a very interesting area. And it's one that I see we won't be delving into today. Which is may be disappointing, I don't know. It's one that the Family Justice Council have been interested in, have given comprehensive guidance. It's one which has been the subject of a number of other decisions, many of which I hope we've referred to, although in fact there are several others. We tried to contain our authorities to the better known ones, but certainly this issue's been grappled with by the courts on a regular basis since this time. And this case, Mills, if you like, it's a look back to the past, really. It seems to have been decided on the basis that here is a figure of needs, never mind how she got there, the wife. This is what the paying husband must pay. full stop, which we say is frankly unprincipled. May I trespass for 1 second on something that Your Lordship's just said, because it is an interesting debate, and it's one that we've touched on here, and it's one that we would touch on more if we had to. But it goes to the question of, as you say, the illness, and whether or not that plays a relevant part in the question of needs. What Your Lordship said in Vince and Wyatt and Vince, I think, by the time it got to this court, was that needs have to be relationship generated. And so in that case, it was the contribution that founded the wife's claim. And that was a relatively extreme observation. I don't say that in any sense critically, but it was a fairly shorthand observation in circumstances where her claim was going to be met from a different area. Your Lordship referred to Lady Hale on the question of Miller's needs and there being relationship generated. And there's also a reference in that case to by Lord Nichols to the same question. And certainly there's been much discussion about whether or not relationship generated is an absolute term, or whether there is the scope around it, looking at the words of Section 25 itself, to bleed into other factors.
Yes.
And it has no authority at all, but those who were acting in Wyatt and Vince wrote a piece about it in Family Law a year or so after Wyatt and Vince, where we said, with great respect to this court, and by the way, I'm taking points that really don't help my case at all, but just as an overall view of this subject, there may be situations where a relationship is exactly what you've just said, where a need is not purely, specifically relationship generated, that it may be, one's trying to think of such situations that may just justify an order of ongoing maintenance.
Yes.
And we could really only come up with medical cases. That there may be others, but it seemed to us that by far the most common situation where that would ever arise would be in health-type issues. And so...
Well, you could think of a situation where somebody was disabled and had been disabled throughout the marriage.
Yes.
That is a statutory factor to be taken into account.
Well, health is a Section 25 factor in any event, of course, exactly. And so that I quite agree, and that would be our submission. But that seems to be, if you look at all the Section 25 factors, that seems to be the most important one, the most relevant to this particular debate. But there are other areas of speculation, and again, with great trepidation, could I refer to Lord Wilson's address to the Bristol students last year, where he postulates the situation of a 60-something-year-old woman who's been married for a long time, has had children, and is told at that age that she's out, and that she's got to fend for herself. And I think Your Lordship suggested 3 years because you were talking about Scotland and talking about the, if I can call it the Deitch Bill, that's an argument that is raging at the moment as to whether or not we ought to adopt a Scottish model, whether or not the Baroness Deitch Bill is going to come into law, whether it should come into law, and a lot of people have got some very strong feelings about it. We thought that was interesting because actually in your summation or your premised fact situation, these days, post-White, a lady in her 60s who's been married for a long time and possibly has children, and perhaps the children have come and gone through, and was married to somebody who was presumably of something approaching a similar age, would have so many more remedies at her disposal than would have been the case prior to White, that actually that may not be a problem. There's capital sharing, there's pension sharing, there's the invasion of inherited wealth, if it's appropriate in that situation. There's pension provision, ongoing pension provision, and it's very easy, or relatively easy, I respectfully submit, that a lady in that position could be fairly provided for. There could be a complete split, a complete equal division of assets, income and capital from the position that they were in. If they had lots of money, it's easy. If they didn't, it would be difficult. So,
well, these are very interesting big points, but I suppose, possibly as a result of my observations, you are really straying from the subject in hand. And for that, I apologise.
Lord, apologies are far from necessary.
There is a distinction between whether somehow or other proper provision has to be made and how it is to be made.
Yes.
Your point was there are other ways of making proper provision
In answer to
for a
that,
lady in that situation.
Yes.
But nevertheless, you accept proper provision has to be made.
yes, well, proper provision
Other ways.
will always have to be made on an application, a first application. Of
Yeah.
course it will.
Yeah.
And that's why, again, I don't want to stray, but that's why when one rereads cases like Dart and Conran, pre-White decisions, and when one looks at those in the context of CNC and Flavel, one can see precisely why Lord Justice Ward was saying what he said at that time, because you had such a different landscape from that which we have now.
Well, we are where we are now, aren't we?
We are where we are now,
Yes.
quite, except that these cases are being dealt with on the basis of CNC and Flavel. And I don't know whether that's outside my remit or not, but on a Section 31 application, this judge, the judge whom we are upholding, this judge relied on CNC. And he took that in 2015 as the guiding principle by which he should interpret Section 31. And, well, we say, and we've said in our submissions, and I see it's now 12:15, so this is going to have to come to a halt. But we say in our submissions that CNC and Flavel are being used still now in all the lower courts because it's Court of Appeal authority. And it's Court of Appeal authority that predated White, and it came from a period, all right, it was near the end of the period, but it came from a period where the approach of the courts, in Conran, one might say very much forced of necessity and of precedent, but Dart perhaps less so, where in Dart the wife, I think we calculated, got about 2.4% of the husband's assets and a costs order as well. And in Conran, the proportion was slightly higher than that, but it wasn't anything like the sort of order that either could have been made at the time, absent authority, or that would have been made after the year 2000. And so we just say that if one's applying the law of Section 31 as per CNC and Flavel, this is very old law, well-intentioned, but it related to a different period. And that's, we say, a highly relevant submission to the outcome of this case, and indeed the wider question of principle of Section 31 applications. My Lords, I have not mentioned Yates, but we deal with it at MS 73. Where the question, again, was the extent to which the paying husband should be responsible for financial choices made by a wife following her receipt of a lump sum. In that case, the facts were slightly different, but it's the same point. The payee wife had applied part of her lump sum award, which was intended to discharge the mortgage on her home. I draw attention to that fact as part of our factual matrix, into a non-interest-bearing bond, subsequently claimed periodical payments to cover that element of her mortgage which remained outstanding. Well, Lord Justice Thorpe, we respectfully suggest, got it absolutely right when he says it seemed little more than common sense that if a recipient of a lump sum twice the size of the mortgage on the final matrimonial home elects to hold back capital made available for the discharge in order to invest in something else that bears no income, she can't look to the payer thereafter for indemnity or contribution to the continuing mortgage interest payments. That seems to be absolutely self-evident. And Lord Justice Lewison expressed it, we say, very pithily and accurately, and indeed coincides with some of the other discussion we've had this morning, and I'll take you straight to the middle of our paragraph 65. The financial consequences of her investment choice are her responsibility. It's wrong in principle, so this is at MS 551, I think, but I'm looking at our skeleton, our written case. The financial consequences of her investment choice are her responsibility. It's wrong in principle for the husband to have to continue to fund the mortgage. Full stop. And we say precisely the same situation applies here. This lady has taken the 94%, or whatever fraction it might be, of the matrimonial capital and has chosen to make certain investments. The judge said it was unwise. The judge was less critical than he might have been on the basis that he said other people were over-borrowing at the time as well. But we ask rhetorically, is that the husband's fault? Is that something that should be laid at the husband's door? I dare say in the North situation, other people did what Mrs. North did. But does that mean that those other paying husbands should be responsible for the financial consequences of what Mrs. North did? And it's the same point in Pierce. It's a question of money provided for a certain purpose. There's no question of a second capital bite at the cherry. But that's effectively, we say, what this wife is trying to do here, effectively, because she's had money for the house, even if the mortgage of £125,000 was reasonable on the figures. If she'd kept that mortgage and not aspired to more expensive properties, and not extended her mortgage by 4 times the original mortgage, nearly 4 times, she may be in a very different situation now. And the cautious husband, who's been paying every day religiously since effectively the year 2000, so 18 years, is now saddled with the consequences of the wife's mismanagement. And frankly, Lords, that's what this case is all about. So can we go further? Can this case generate statement of principle from this court? It's a matter for you. It's not a matter for me. We've made our submissions. We say it can and it should. If you say, no, it shouldn't, so be it. But the 3 cases that you've asked me to address, I hope I have, because fault is very much involved in the 3 cases that you've referred to, and it was her fault, and he shouldn't pay. Lady, those are my submissions on that limited question. Unless I can address any other issue that I've managed to miss.
It seems as if there are no more questions for you, Mr. Cayford. Thank you very much indeed.
I'm obliged.
Thank you. Ms. O'Rourke?
No, my lady.
Mr. Fian.
My lady, well, I'm not going to be as adroit as Mr. Cayford. I'm afraid I'm one of those who uses advocacy a bit of a blunt instrument. So I'm going to give you some headings and see if I can help you with our approach. I'm going to deal, my lady and my lords, with the 3 cases identified by Lord Wilson: North, Pierce and Yates. Under the heading of North, there are subheadings of what I'm going to deal with. The question of insurer against all hazards. The question of fairness, once the gates are opened to the Section 31(7) exercise. And whether unwise equals mismanagement. In the case of Pierce, I'm going to deal with the question of double counting, and whether the fact that in that case it was double counting of capital is the same as double counting as alleged here when the question is rent. And in the case of Yates, which was an interest-only mortgage, the question of how that is a different exercise, if at all, to what is happening here. So those are the way I'm going to address those 3 cases. I am going to go a little wider, if I may, because along with Mr. Cayford, I say there are relevant issues in some of the other cases in the bundles. In particular, the question of need, and in particular the way in which need, which may not be specifically generated by the choices made in the relationship, should be addressed, and I'll be going to SS and NS about that. My lords, I'm going to begin, if I may, with just a review of the facts from, as it were, the wife's point of view, as you've had a review of the facts from the husband's point of view, because they go to the question of fairness, which is part of the Court of Appeal's approach, the Court of Appeal specifically directing itself as to the statute particularly. and I'm going to look at how matters are addressed in the judgment of Judge Everall, Queen's Counsel, because although it is for Mr. Cayford, as it were, to defend that judgment, there are parts of that judgment which I also say the court must take, because there are factual findings of importance within it. As to the history, what has been set out by Mr. Cayford on behalf of the husband is that he had an expectation that the capital provision made for the wife in 2002 would be fully used for the purchase of a house. That if that had been done, she would have had £1,100 a month to live on, and we wouldn't be here today. If she'd simply done that and stayed there, we wouldn't have this case at all. He criticises her for taking out a mortgage in late 2002, but says that even if she'd stuck at that mortgage, it might have been manageable. And he says that, in fact, what has happened is, though His Honour Judge Everall, Queen's Counsel, didn't find it to be wanton or profligate, the impression made by Mr. Cayford's submissions is that it is so unwise as to amount to being effectively profligate or wanton. We say that it has to be looked in this way. These parties were together in a marriage for 13, nearly 14 years. They had a child, the full responsibility for whom, in terms of day-to-day care, fell upon the wife. They tried to have another child. There was a very late miscarriage of that pregnancy in the 20 or 23-week period, which understandably caused significant medical difficulty for the wife. They had started 2 companies. The wife says, I know the husband doesn't necessarily accept this in full, the wife says started 2 companies together. She helping those companies to be set up, she doing what she could to assist in the initial running of those companies, and she having a 50% shareholding in them. For that reason, they were a partnership. When it came to 2002, she made clear that her housing need was greater than the capital available. It was also clear, we say, from the reading my Lady Hale gives to the small passage in the Form E you were taken to, that the expectation was that she probably would return to work. She couldn't do so as yet, but that there was an expectation she would return to work. And indeed, can I interpolate that later on in 2002, although they had decided as part of the settlement at FDR that Lawrence would not stay in the private school he was attending, they did agree to leave him at that private school, and the wife assumed 1/3 of the fees for that school, which were, for her, £9,000 a year to find. So plainly there was an expectation, shortly after FDR, that she would be returning to work, since how could she manage those fees on £1,100 a month? She did return to work, and worked solidly, although, of course, through illness, not very effectively, and continues to do so. She has made what contribution she can financially to herself and her situation, although she has had to rely upon the periodical payments agreed by the husband in 2002. I make this point also in relation to the facts. This was an order which was a consent order. The lifetime maintenance order was not forced upon the husband. It was a transaction that was made between them, fairly and openly, that she would give up 50% of the companies that she had. He would have full control of them and access to all of their profits. And she took what we have to say is a modest periodical payment in return. In 2002, even in 2002, £13,200 a year was by no means a lavish lifestyle income. I say all of those to rebut, insofar as it needs rebutting, some of the way in which her actions and her approach to this case have been characterized elsewhere. Mr. Cayford adverted to the notion of the phrase meal ticket for life. It's a phrase which is included in the written case for the husband, albeit disavowed. This is not a case, we say, in which a woman of rich tastes receives significant income for luxurious living. It is a case in which, from the start, the income provided by the husband was probably insufficient for anything other than the absolute basic needs. And even as added to by the wife, just about met the needs of herself and a child in an appropriate way, given the reasonable standard of living that they had during the marriage. That, we say, is the background to this case, and those are the facts we add to the factors set out by Mr. Cayford. The findings of Judge Everall are the most important analysis of the facts, we say, in this case. And they are in his judgment in the core volume. In particular, his analysis of certain elements of the facts, and I'll have to rely on someone else for the MS number since they're not, I'm afraid, on the volume, so I apologize in advance. But it's volume 1, core volume, page 143 is where the judgment begins. Oh, it is the same in the core volume, I'm grateful. I'm going to ask the court to look at the judge's assessment of the facts which we say are appropriate from the judgment. 149 is the first part I wanted to look at.
You couldn't do paragraph numbers, could you?
Yes, I can.
Thank you very much.
The judge sets out the evidence he's heard, and it's important to remind the court. Neither of us have put Pigslowska or Gojkovic before the court, but the court well understands the advantages of a first instance judge in coming to findings of fact. He sets out what he heard, that he heard evidence from the husband and wife, and he heard evidence of a robust nature from husband and wife. You've seen how the case was put on behalf of the husband at first instance, the use of a private investigator, specialist counsel, 2 days of submissions and argument, and a reserved judgment. This was a full analysis of what was going on, not just during the marriage, but after the marriage and in the 13 or so years up to the 2015 hearing. Over the page, he sets out the husband's income, conducts a full analysis of that from paragraph 26 onwards. In paragraph 29 and 30, he shows that at that stage in 2014, the husband's income was £48,000 a year being withdrawn from the company, or the companies by then. In addition, his new wife was taking a small salary of £7,000 per year, probably at the income tax threshold level. Plus she was working as well as a classroom teacher.
So what do we make of the second sentence there, Mr. Fian? Has something gone wrong in the maths?
48 plus 7 is 55, of course, rather than 52. So there is
Thank
a
you.
problem in the maths.
Yes.
So £55,000 a year being taken from the company. But that's as at 2014, which was the accounts for that year. The judge does say, in fact, that ordinarily the figure was significantly larger. And in paragraph 29, you'll see that the average of the last 3 years was £71,000 per year. Pausing there, you heard from Mr. Cayford some veiled criticism of the wife, that the figure taken for her income in 2014 was much lower than her income for the previous 2 or so years. Perhaps wasn't put as criticism on behalf of by Mr. Cayford just earlier, but it's certainly put as criticism within the written case, the suggestion that somehow the wife had massaged the figures down for that year, which we reject. The fact as to the wife's income, I'll come to in a moment, but Judge Everall gives a very clear explanation as to why he takes that particular year and that particular figure rather than previous years, but I'll come to that. But he sets out what was available to the husband, and it's also instructive to look at paragraph 34, if we may. We don't make a particular point about valuation of the companies in 2002 when the consent order was arrived at. But it is interesting to note that in terms of value of the company, what it was worth to the family and to the husband, that in paragraph 34 the judge finds this, that in 2001, the amount of profit allocated to him was £57,000, very nearly. Shortly after the consent order, taking an average of the previous year and that year, it would have been around about 45,000 gross. But interestingly, 6 and 7 years after the 2002 order, those companies were generating sufficient for him to draw as income £160,000 in 2008 and £129,000 in 2009. So in looking at the fairness of what went on between the parties, and whether or not now we look at fairness by having regard to the history of the matter, the wife gave up a 50% interest in companies which were generating very significant income just several years after the consent order was made. And we say that has to be added in to looking now at whether it is right that a particular level of income should continue. It doesn't entitle her by any means to luxury, but when looking at need and whether basic need is an issue in this case, the giving up of a potential right to that level of income is a factor, we say, to be held in the balance. Going on to other findings made by the judge, under the heading Wife's Income and Assets, the first couple of pages of the judgment after that deal with the wife's illnesses, and it's clear that she did have significant medical difficulties up until 2010. The judge, to a degree, discounted those as a present problem for her. He sets out the house moves at 44 to 50 and has proper regard to all of them. And then comes to the wife's earning capacity at paragraph 53 to 55. These are the paragraphs which explain why the wife could not earn more than the judge found in that judgment, £18,500 net per year. And that it is not to do with any illness that she's had. It is not to do with whether or not she can work an extra couple of days a week. It is to do with the fact that the circumstances of her business changed and the competition increased and the use of online discounting vouchers to bring customers into the business started to end. The judge found that she could, from a medical point of view, work up to 4 days a week, but that there were not the customers. And looking at that matter, having had that robustly analysed and examined in a two-day hearing, he, as the judge who heard the evidence, found, I take this figure because I find this is as much as she can earn. He didn't have to look at 2012 or 2013, he had to look at what she could do at the time of the hearing. And the evidence that he had was that this was the maximum that she could earn. So the fact that this application to end maintenance, as the husband made it in 2015, wasn't made 2 or 3 years earlier is of no account. Had he made it 2 or 3 years earlier, he might have had a better chance. But 2 or 3 years later, she'd have been left with not enough to live on. So in a sense, that hazard, that arbitrariness of timing, goes very much both ways. The main point is, however, that the figure taken by Judge Everett is fully explained and fully justified by him. And as I think the court has said earlier today, it's not for the court to go behind that given the reasoning that the judge sets out. As to an analysis of what the judge does, they start at the conclusions at page 158, paragraph 61. He's guided by section 31.7 and refers again to North and North. It's referred to much more fully earlier in the judgment when he directs himself as to the law. He comes to a decision as to the wife's budget at the end of paragraph 62. And he takes full on the submission of Miss Heaton for the husband, submitting that the husband should not be looked to in order to fund the wife's housing costs in circumstances where the wife has capital funds to meet her housing needs and the wife has squandered them. As she puts it, the wife has no capital remaining. He disagrees with that as a matter of principle, though of course he doesn't increase the maintenance in fact, having found that there was indeed a shortfall. Importantly, he then says this. It's paragraph 67, and we've been here before. In my judgment, it was reasonable for the wife to be ambitious and to seek to re-establish her business as a beauty therapist. In those circumstances, it was reasonable to take on a mortgage. I accept her evidence her health difficulties interfered with her earning capacity, and she underwent surgery in 2004. She did extend her mortgage and did not satisfactorily explain why. Paragraph 69, and this is perhaps the crucial paragraph in this case. The wife did not manage her finances wisely. These were choices she made. However, the choices which she made have to be seen in context. That context was that she took on too high borrowings. She was not alone at the time in doing so. It has not been shown she was profligate or wanton in her approach to her finances. She was a single parent, although, of course, Lawrence had the support of his father. Her health difficulties continued with repeated surgical interventions till 2010. I accept this meant that in the years to 2010, her attempts to establish regular and secure employment were hindered. Furthermore, the wife is not a good businesswoman. Therefore, when her earnings did not increase, she was not able to adjust. Can we please, my lady and my lord, go to North? I'm just going to check the time. I have time. It's MS 467. And if I may, I'll just refer thereafter to paragraph numbers. Can I begin by, again, perhaps in an effort to rebalance, going into the facts of North. North was a case in which a wife came back for maintenance 27 years or thereabouts after a divorce had taken place and a financial order made. That order was an order which gave her sufficient for a good house. It was a case which in its terms was a big money case in those days, and a very good income. She gained reliable ground rent income, which was more than sufficient for the rest of her life. That was at the time of the initial financial order. Thereafter, the husband, who is plainly a very generous man, added to what she had been awarded at dissolution, with more ground rents and more financial assistance, including financial assistance for her own parents. From that completely secure and well-maintained, not basically, but very well-maintained existence, she decided to up sticks, sell everything, and go to Australia. In Australia, she invested in the stock market, not very successfully, indeed unsuccessfully. But what she did, which causes particular criticism in the case, was live what was very much the high life. And it's paragraphs 33 and 34, 32 to 34, which is 155, MS 477, in which criticism is made of that. Now, this is a case, my lady and my lords will recall, in which a district judge had made significant findings as to the misconduct of the wife in behaving the way that she did. Findings of fact. He also then, in his judgment, as it were, plucked out of the air a figure for maintenance that she would need going forward of over £16,000 a year, and didn't give a proper explanation for that. And that was one of the main reasons why the appeal was allowed. But this is what the Court of Appeal said about the way in which she behaved. Paragraph 33, in the present case, the wife's failure to utilise her earning potential, her subsequent abandonment of a secure financial future provided for her by her husband, her choice of a more hazardous future in Australia, together with her lifestyle choices in Australia, were all productive of needs which she had generated and for which the husband should not, as a matter of fairness, be held responsible in law. Even the applicant's subjective sense of fairness should surely not encourage her to expect that someone from whom she was divorced so many years ago should be required in law to compensate her for the financial consequences of ill-advised choices. Contrast paragraph 34. However, I would not necessarily, as the district judge appeared to, put the wife's investment losses into the same category. Whilst it can, of course, be said that stock exchange investments are less secure than ground rents, they're a more conventional form of capital investment and carry the prospect of capital appreciation to offset the erosion of inflation. Thus, even had the wife been content to remain in Sheffield, she might reasonably have decided to exchange ground rents for stock exchange portfolio. The consequential loss seems to me more the outcome of hazard and there to be characterised as misfortune rather than mismanagement. It's these paragraphs which we say go to the question of what does mismanagement mean. The court in North says that a prodigal wife can't return and expect more. The judge in this case describes the wife's conduct as unwise. She managed her finances unwisely. What does mismanagement mean, therefore, we say, in the context of this case and the context of North? There is in one of the cases before the court, and it occurred to me whilst listening to Mr. Cayford, and I'll have to find the reference, and forgive me if I don't have it to hand right now, but in one of the cases before, there is a statement made by a judge in the Court of Appeal which warns himself about taking a word from an authority and treating it like it's a statute. Authorities, cases, judges are dealing with facts, dealing with nuance, and trying to put before those coming after them, looking for precedent, trying to give those people guidance in a reasonable and broad way, and to fall upon a word like mismanagement as if it's a statutory construct may well be an error. One has to see that word in the context in which it arises. The mismanagement in North was the extravagant choice, as it was found on the part of the wife, to give up a completely secure, fully funded, capitalised income and housing position and squander it. That is what she did. That was the mismanagement which the husband could not be expected to compensate for. But doing what a lot of other people do, investing in the stock market and losing her shirt, was not mismanagement. Engaging in conduct which is the sort of conduct people engage in to better their lives or try and get on or be ambitious is not mismanagement. Now we say, in this case, you have to look at what the wife did and decide whether or not what Judge Everall found when he said she was not wanton or profligate was that she had not in fact mismanaged in these terms the capital that she had, and whether in saying that she was not wanton or profligate but unwise, that what she had done is do what other people do, invest, try and get ahead, make a bit more for herself and her child. What was happening to her was misfortune rather than misconduct. When Judge Everall says at paragraph 69, she did not manage her finances wisely, is that different from saying she managed them unwisely? It may well be. These are perhaps semantics, but again, we are looking to apply to words in an authority the sort of precision we expect from a statute. It is difficult. What he says is the wife did not manage her finances wisely, but the choices she made have to be seen in context. She took on too high borrowings in property in the early 2000s. She was not alone at the time in doing so. It has not been shown she was profligate or wanton in her approach to her finances. He then lists what the problems were for her: a single parent, health difficulties, the problem that both of those things had in helping her to establish a greater income, the fact that, unfortunately, misfortune, not misconduct, she's just not a very good businesswoman. But this was, the picture is, a woman who was trying, who was suffering from ill health, but was working anyway, who was in receipt of maintenance from her husband, but never went back to court to increase it, even though she couldn't manage, who was paying a third of the boys' school fees. All of those this judge had to take into account when coming to the conclusion that she was not profligate or wanton. My lady, my lords, we've handed in this morning an Oxford English Dictionary definition of the word prodigal, because Mr.
So you're disobeying your own injunction.
I am. I apologise. We put that in because it's part of the case, part of the written case, and part of the oral presentation made by Mr. Cayford this morning, that the words profligate or wanton are not used in North. But the word prodigal is.
Prodigal is.
And prodigal means reckless, wasteful, extravagant. We say you look at the words mismanagement not as a statutory word and not as a word which one interprets. I'm going to use Latin. I beg your pardon.
We don't mind Latin in this court.
It's not a word you analyse sui generis. It's a word you analyse a justum generis. You see it in its context. And in the context that it's put in North is of extravagance, wantonness, wastefulness of a woman in that case who, over the course of 20 or 30 years, had every opportunity to be completely self-sufficient, but threw it all away, rather than a case in which a woman makes unwise choices, but doing her best to provide for herself and her child in the context of relatively low monthly maintenance from the husband.
Do we actually get wasteful or profligate or wanton or extravagant in North?
In North, prodigal.
We get prodigal.
We certainly
Yes.
get prodigal, and eventually, from Mr. Justice Bennett, we get depletion.
Yes.
So any more than that?
No.
Okay.
Prodigal is the word that is used.
It's prodigal the word you fasten on.
Yes. I fasten on the word prodigal, but I also fasten on the description.
Yes.
In the descriptions in 33 and 34,
Yes.
so that we understand what the word prodigal means. It's 33 that sets out those actions of the wife in that case which were prodigal. Section 34, investments, unwise investments, riskier investments than ground rents, misfortune,
Got that.
is not.
But getting away from adjectives, Mr. Fearn, what do we make of the fact that in order to buy the Weybridge property, she did borrow a lot of money, but let's put that on one side as not being something for which she can be criticised. In the 3 years that she was there, the mortgage increased by £93,000,
Yes.
which she was not able satisfactorily to explain to the judge.
Yes.
Now, what do you say about that?
That the judge took it into account when deciding whether or not she had acted wantonly or prodigally. He knew that. The whole thing was put to him. The whole matter was fought out over 2 days. And having seen her in the witness box and seen the husband in the witness box, and analysed the finances and the facts of the issues far more than this court is able to do, arrived at a clear and reasoned conclusion that in spite of all that, he could not say that she had acted in a way which we say North requires you to act before the husband has no liability to continue to maintain them. I'm afraid that for your lordship may be overbroad, But
Well,
the fact is the judge arrives at a conclusion about her conduct.
I think he took that into account in paragraph 72 when he decided that not the entire burden of your client's rent should fall on the husband.
Well, that may be so, and I'm going to address in a different way the approach which he took and the approach which the Court of Appeal took.
Very well.
When I come to the question of needs, because fundamental to this case is a question of needs. And a further finding that the judge made in this case, Judge Everell made in this case, is in paragraph 70, where he describes the budget as a figure set to meet only her basic needs. So that one is dealing, in this case, unlike any of the other cases, certainly any of the three cases that are central to the determination of the court in this matter, one is dealing not with a case where there is surplus, not dealing with a case where income needs were largely capitalised with some additional, in one of the cases, extra short-term payments, not with a big money case at all, but a case which is much more like the sort of cases that have to be dealt with in the family courts up and down this country every single day, a case where needs are everything, basic needs only are addressed. My Lord, it's just before 1 o'clock, and that might be a convenient moment. That suits your lordships.
Well, if that suits you, it's 5 minutes to 1, but that's...
I'm sorry,
if that's the point at which
my old watch is fast.
You don't get any more time by giving us
No.
more time. Thank you. Well, we'll adjourn now and look forward to hearing from you further.
Thank you, my lady.